Good morning, everyone. This is Brian McSherry with the Independent Insurance Agents of Illinois, along with Bill Larson of NetGen. I'd like to thank you for taking time this morning to attend our webinar. Today's webinar should last 25 or 30 minutes. We encourage everyone to ask questions. You can use the field at the bottom of your screen to send us questions during the webinar. We'll answer as many questions as we have time for. If we don't get your questions answered, we'll follow up with each of you at the conclusion of today's webinar. And finally, today's webinar will be recorded and posted to our website on our cybersecurity page. You can find that at iaofillinois.org/cyber. This is our second webinar in our four-part series, Avoid an Agency and Personal Financial Disaster. Make cybersecurity your agency's priority. In our previous webinar, Protecting Your Agency's as well as your personal financial survival, we discussed the personal financial exposure an agency has to a data breach. As we said, this is a very real possibility and an urgent issue which must be addressed by every agency and agency owner. We felt this needed to be addressed and that the association needed to help our agents understand the gravity of the situation and provide them with tools to protect themselves and their agencies from the potential financial fallout from this exposure. As we discussed in our last webinar, the Independent Agents Council for Technology, or ACT, has determined that the potential exposure to its agency members were so severe that they developed the Agency Cyber Guide 1.0, which has now been updated to the Agency Cyber Guide 2.0. The introduction to the Cyber Guide states the following: handling sensitive information is now one of the most critical responsibilities faced by the modern insurance agent. Independent insurance agents and brokers must properly collect and protect sensitive information every day. This means they must comply with state and federal regulations with regard to privacy laws, as well as adhering to customer service best practices standards. These acts and regulations can be difficult to address given the responsibilities agents encounter every day, but they must be a priority. In order to help us begin our educational process for your cybersecurity, we've partnered with Bill Larson of NetGen Data Security Consulting and Profit Protection Risk Management Consulting to help guide us through the process. This is the second in a series of 4 webinars Bill and I will present on the topic. We will also be presenting a 2-hour CE course at this year's convention covering data breach and security, as well as a panel discussion on risk management. Bill has worked closely with IAB ACT over the last 7 years. Bill was a major contributor in developing the ACT Cyber Guide 1.0 and 2.0, which he presented at the National ACT meeting in Chicago. Bill is a member of IABA ACT Security Issues Work Group, which is working on development of ACT Cyber Guide 3.0. Bill is also chairman of the IIABA ACT HIPAA Work Group, which led the study of compliance and liability exposures associated with data privacy laws for the independent insurance agent. Bill has also co-authored articles on data privacy and security for various insurance publications and worked with other state associations on the topic. Bill, can you get us started with today's data breach program?
Sure. Thanks, Brian. Again, in our last webinar, we focused on a brief overview of the exposures faced by agencies due to the current data privacy laws and your members' contracts, which, again, as we talked about, they mandate that their agency must be in compliant with these data privacy laws. And again, they could use NetGen to help them to become compliant with these laws. We also discuss the first and third party liability exposures your members face and their options to cover these exposures, again, by either purchasing a data breach policy along with a program to help their agency to become compliant with these mandatory privacy laws, or they could just simply choose to self-insure these exposures out of their agency profits, defy these laws and the requirements in their agency contracts. So again, obviously up to every agency. In developing the webinars and CE programs, IIA's goal is to help you and your agency fully understand your requirements under the current data privacy laws and the ramifications if you choose to be non-compliant. Now, we believe that your compliance with the current data privacy laws and with your current carrier contract requirements will determine your personal financial well-being as that of your agency. So extremely important. In our last webinar, we discussed the possibility of losing your business to a competitor if, first, they showed your client the federal and state data privacy laws that all agencies must comply with in order to protect their clients' private information. They also discussed insurance company agreements which require compliance with these laws. They explained how their agency is in compliance with these laws. They showed that they had purchased a data breach policy to provide protection for their clients' information. And then they gave your client a checklist of questions to ask what procedures you have in place to protect their information. So, as we said in the last webinar, how easy would it be for your competitors to take your clients if you are not in compliance? So think about that. What would happen to your agency and your client base if your clients discovered that your agency was not properly protecting their personal information and that your agency was in violation of both state and federal laws and the requirements as stated in your company contracts? So will you be able to show them that you've purchased a data breach policy and either purchased or internally developed the required compliance programs to help protect the personal information? And again, non-compliance could lead to a potentially unlimited liability exposure both for you and your agency. So today, what we're going to do is we're going to do a deep dive into the financial exposures you and your agency face from these exposures. So what you can do, you can protect your agency from most of these issues we discussed by purchasing a data breach policy and a data privacy compliance program again, or you could just choose to self-insure these exposures and pay the costs and claims out of your agency profits. So again, up to you. In the last webinar, we stated that the major first and third party expenses an agency is exposed to in the event of a data breach or a loss, and that your agency is legally required to take action, which could result in significant expenses for your agency. What we're going to do is we're going to now go into much greater detail in discussing what these expenses are, and we'll begin this with our first party expenses that your agency is exposed to. So the first party expenses begin with legal expenses. These costs are varying significantly over the board. These are costs incurred by your agency for legal services caused by a data privacy violation. Next, we have computer forensic expenses. This covers the cost of determining the cost of a data breach and how to prevent future breaches. Now, the average cost is between $5,000 to $15,000 according to Vestige Cybersecurity. Third one we have is notification and call center expenses. According to IRMI, privacy notification and crisis management expenses includes first, the cost of hiring a forensics expert to determine the cause of the breach and suggesting measures to secure the site and prevent future breaches. Secondly, hiring a public relations agency to assist in dealing with the breach. Third would be setting up a post-breach call center. Next, we would have notifying affected individuals whose personally identifiable information, which is PII, has been compromised. In most cases, this is done with first-class mail. Then we have monitoring these individuals' credit. Also, paying the cost to restore stolen identities as a result of a data breach, such as notifying banks or credit card companies. And again, we'll discuss an agency's legal liability costs when we discuss third-party expenses, which could be incurred by the agency through this process. Now, Illinois requires a direct notification of all customers whose data has been breached. And in a study conducted last year by Vance and Bourne, 76% of those interviewed said that they would leave the companies who lost their information. So we believe that that's critical. Fourth, we have cyber extortion expenses. Now, what this does, this covers the cost of ransom by a third party. And the third party is one who demands payment to keep from disclosing the breached information to the public or by causing damage to the agency's private data. The use of ransom has increased significantly over the past year. And as an insurance agency, you rely on computers to operate as a business. Ransomware is malware, and what it is, it's intended to lock up an agency's data and hold it for ransom. So as a result, an insurance agency can experience high forensic costs to restore data and the breach interruption. So we're talking some big bucks here. Fifth one is data restoration expenses. This covers the cost of restoring the agency's lost data and diagnosing and repairing the cost of the loss. Next, we have business interruption expenses. This covers the expense due to the loss of business income from the data breach. So how would your agency be able to cover this type of expense if you're not in business? To me, it's an interesting question. How are you going to pay for this? Next is dependent business interruption expenses. These are expenses that the agency sustains as a result of a third-party security breach. An example would be this would include a breach by any of your agency management systems. An agency is legally responsible for all the information which is sent to a third party. If the third party has a loss, the agency is liable for payment of these losses, even though the loss occurred with the third party. So many agencies use third-party management systems as a core in their operating structure. I have not seen any contract with any agency management system which states that they will cover an agency for a data breach loss while they are in possession of the agency's information. So this is why it's a requirement in the Graham-Leach-Bliley law that there must be a contract in place with a third party if a person's information is to be sent to that third party. Again, since the liability for this information remains with the agency, which again can lead to a significant third-party liability suit. And we will discuss this at length in the later webinars. Next, we have fraudulent transfer of funds expenses. Now, what this does, this covers theft of money, securities, and other forms of tangible property through computer fraud and social engineering schemes. Hackers are looking to trick insurance agencies and their clients into wiring money into fraudulent bank accounts. What happens, these attacks usually originate through phishing emails or stolen login credentials. Hackers are increasingly targeting business and stealing senior executive officers' credentials. And what this does, this results in compromised bank accounts and wiring money out of their personal bank accounts. Next, we have possible identity theft monitoring and protection expenses. Identity theft happens as a result of security breaches where sensitive information is stolen by the hacker or inadvertently disclosed. Now, this includes items such as social security numbers, birth dates, driver's license numbers, basically any of the information an agency has on its policyholders. In the event this information is sold in the dark web, this can potentially create an unlimited liability exposure over an unlimited number of years for the agency which had lost this information. This will be discussed more fully in third-party expenses, which again involve lawsuits against the agency by those individuals whose information was breached.
That's a long list of expenses an agency has exposed themselves to in the event they choose to self-insure that portion of their exposure. Bill, Could you review the expenses an agency faces from third-party exposures to a data breach?
Sure. As we discussed in our last webinar, third-party expenses are the costs associated with regulatory compliance, as well as defending and settling cyber-related lawsuits, which really can be a daunting experience. So our first set of expenses are privacy and security-related litigation expenses. These are lawsuits filed by customers or employees against the agency who's responsible for the security of their personal information. So if a client experiences a cybersecurity breach and sues, normally the third-party liability portion of their cyber liability policy would respond and they would pay for these expenses. The second set of expenses are regulatory fines. These are fines issued by state and federal regulators for improper protection and procedures related to a client's personal information. And third, we have payment card losses. If you take credit cards, you must be compliant with all PCI requirements. So it's then at the option of the agency. If the agency chooses to self-insure these exposures out of their agency profits, that again is their option. We will now review some of these expenses which we're talking about, which would be involved in the area of the cyber-related lawsuits. And the first area we'll cover is one which has gotten the most notoriety, and that is identity theft. It's unfortunate that the reality of identity theft has become a daily occurrence, really. Recent statistics state that about 60 million American citizens were victims of identity theft in 2017. And this type of theft goes far beyond simply stealing someone's credit card or social security number. This alarming statistic shows that there's a wide variety of personal data theft and identity fraud going on both on and offline. So for this reason, it's important to review some of the different kinds of identity theft. So our list will start with Social Security identity theft. Once this information falls into the wrong hands, the repercussions for your client could be extremely severe, as the criminal can use your client's Social Security number to create any number of crimes which could impact your client. Once the Social Security number is sold into the dark web, it can be sold over and over again, creating unlimited claims over an unlimited number of years. The government will not reissue a new Social Security number, so this potentially creates a situation where you and your client are exposed to an unlimited number of claims over an unlimited number of years. This is daunting. Next, we have driver's license identity theft. Stealing your client's driver's license can lead to unauthorized purchases under their name. Driver's license can also be used by the thief to apply for various forms of identification. The thief's picture will then appear on the official documents containing your client's personal information, making them virtually untraceable. Next, we have tax identity theft. This occurs when a thief obtains your client's Social Security number and uses it to file a tax return in their name. Next, we have credit or debit card identity theft. This one is one of the most common types of identity theft, and this involves using your client's information to make unauthorized purchases. This is the one you see in the news probably the most. Now, next we have new account takeover identity theft. This occurs when a thief uses your client's data to open new accounts in your client's name. This can range from store credit accounts to government benefits to healthcare services. The options are virtually endless. Next, we have criminal identity theft. Criminals can steal a driver's license or other personal information with the intent of keeping this information when they get arrested. The criminal will provide your client's name and information while under arrest, and the charge will then appear on your client's permanent record. In some extreme cases, there could be warrants for your client's arrest issued under your client's name. So very, very difficult for the client to work with. Next, we have medical identity theft. This type of identity theft is one of the harder to identify. It occurs when an individual steals your client's information in order to get medical services. Next, we have child identity theft. Child identity theft is becoming more and more common, and it's harder to detect, and it's much harder to detect than other types of identity theft. Using a child's social security number, it's an easy way to slip under the radar of theft detection, and children don't have a tax history, so any number of accounts, loans, or government benefits can be opened in their name. Only when a child turns 18 and tries to apply for these things on their own do they usually realize they're a victim of identity theft. Now, next, we'll cover some of the claim examples which affect insurance agencies. First, we have a CFO of an insurance agency in Virginia had discovered that a fraudulent third party had compromised his computer and was attempting to wire money out of the bank account. Upon the forensic review, it was determined that the hacker had gained access to confidential information such as social security numbers and sensitive financial information. Now, next we have a small insurance agency in Northern California. They experienced a ransomware attack while their office was closed on the weekend. They identified the ransomware attack on Sunday, and the agency then decided not to pay the ransom and immediately began the work of removing the malware. Upon removal, roughly 30% of the data was still corrupted, and a few of the computers were not usable at all. The insured accrued about $50,000 in costs for recovery of data and the computer restoration. Our third one is an insurance agency received an email from a wholesale broker asking them to forward payment for a policy that was recently bound. The employee who received the email overlooked that this was a fraudulent request and that the payment was being transferred into an account the agency had never remitted payment to. Upon completion of the transfer, the agency quickly learned that they were a victim of a funds transfer fraud and had transferred $42,000 into the account, which was lost to the agency forever. Next one would be a mid-sized insurance agency found that malicious links were being sent internally as well as to their clients from one of their departments. And it was also discovered that one of the employees' accounts had been compromised and that the malicious emails had been sent to everyone on their contact list. The credentials were immediately changed. Again, however, forensics was still needed to determine how the perpetrator had accessed the system and whether PII had been stolen or compromised, and this claim is ongoing. Next, we have an insurance agency in California who received their phone bill and was surprised to see it priced at $18,000 for the month. Now, their bill is normally well under $1,000. The agency quickly learned they were included in the widespread telephone hacking scheme that had affected numerous businesses. And what had happened, hackers had set up a phone number where if they called the number, the caller would be charged $3 per minute. So the hackers then tapped into the agency's voice over internet protocol phone system and accrued a massive phone bill. So this is just a very small portion of the potential claims and expenses which an agency is exposed to if either a data breach or simply a loss of personal information occurs within the agency. Now, I would very strongly suggest reading Brian's article in the July Insight issue. That's on page 33. I would like to share a small portion of this article for you, and it states the following. The fact is, cybersecurity is not going away and is becoming one of the most challenging environments for independent agencies of all sizes. Perhaps the words if and when would apply. It's not if your agency will be hacked, but when. I wonder how many of your customers will continue to do business with you after they find their personal private information is out on the black market as a result of your lack of security protection. It is your business's your business worth the investment? I think so. Protecting personal private information within the agency environment is a must. Agencies must have safeguards in place before they attack, as well as a response protocol following a data breach. So why should you care about this stuff anyway? You're a local agency in a small town with one employee and nobody cares about your agency. You could not be more wrong. The hacking community calls you the low-hanging fruit. You are easy because you don't view security as a priority. Handling sensitive information is now one of the most critical responsibilities faced by the modern insurance agency. Independent insurance agents and brokers must properly collect and protect sensitive client information every single day. This means complying with state and federal regulations, as well as adhering to service best practice standards, and every state now has data breach response laws. So, just to repeat this thought again, this is such a serious issue. It is no wonder that the insurance company producer contracts identify this issue and make the agent responsible for all losses to the insurance company in the event the agency is negligent in not being compliant with protecting their clients' personal information. So, here is some wording from a couple of agency producer agreements, and we'll discuss that in much greater detail on our next webinar, which will be on September 8th on agency contracts. So the first one is from a national insurance company that many of you represent, and it states the following. You agree to purchase, keep in full force and effect, and maintain at your own cost during the entire duration of this agreement a cyber insurance policy with limits of $1 million per claim and $1 million aggregate, covering loss arising out of media liability, network security liability, privacy regulation proceedings, including any resulting fines, and privacy event expenses, including forensic costs to determine the nature and extent of the breach, computer and data loss restoration, voluntary and mandatory costs, credit monitoring services. You warrant that you have in place reasonable controls to protect personally identifiable information and training for your employees and agents regarding appropriate cybersecurity. Producer represents and warrants that as of this date of the amendment and continuing through the terms of this agreement, it complies with all applicable cybersecurity laws and regulations. The producer represents and warrants that its security program is in effect to protect, and they put the name of the insurance company in this spot, protect their information systems and non-public information. So because of the warrant in this is extremely serious. Our second agreement is from a regional mutual insurance company, which many of you have contracts with, and it states the following. The agent will defend, hold harmless, and indemnify the company against liability, including the cost of defense and settlements imposed on it by law, including, without limitation, the Fair Credit Reporting Act, the Illinois Privacy Act, and any applicable privacy law for damages sustained by policyholders and caused by acts or omission of the agent.
Thanks, Bill. I'm also seeing more and more company contracts with expanded hold harmless agreements as well as contract-specific data breach language. So this is becoming more and more prevalent. Even some of the older contracts are being revised by addendums. So again, I think this is an extremely important issue for our members. Again, our webinar on September 18th will review agency contract as their data privacy security compliance requirements. An agency must be compliant with both state and federal laws, including data privacy security laws. This language is contained in many agency contracts, as we've previously discussed. These contracts are executed both corporately and personally If your agency is not compliant with these issues and the insurance carrier incurs a loss, by contract, the agency is required to reimburse the carrier for all losses it incurs by the negligent acts of the agency. We've provided exceptional products for our members to help them be compliant with current data privacy laws as defined in the company contracts and with current federal and state laws by going to our website or contact NetGen to receive your toolkit to start the compliance process. Just as a reminder, we also offer some great cyber liability products available through Beasley, Evolve, and Coalition. You can find these products on our website, on our cyber page, or in the products and services at iaofil.org/cyber. So go out, take a visit. There's a lot of information out there. Bill, it looks like I've been keeping track of, as we've been going through here, we do have some questions and we do have a few minutes left. So let me throw a couple of these questions out. We can provide answers to some of our participants. First one is, could you talk about agency management system a little more? Did I understand correctly that my agency management contract has data breach language in it?
Well, Brian, the ones I've seen, no, it really doesn't address it at all. And so again, here's where we come back to both the Illinois law and Graham-Leach-Bliley define that you must have a contract with your third party. So you're sending the information to the third party. The law in both Illinois and GLB federally both state that you are responsible for that information, and if a breach occurs with that third party, you will cover all the costs of that breach. So that's very, very significant. So if you don't have a contract with that third party, it will roll back downhill to you.
Okay. Let's see. The next question. Most of my company contracts are old ones. Would there likely be data breach language in those?
Okay, well, we obviously went over a mutual company and a national company and what they're talking about data breach, and those are relatively new. The mutual one is actually 3 or 4 years old. But no, what happens is at a bare minimum, when you read your contract, it says the agent must be in compliant with state and federal laws. Okay, so boom, you got the Illinois Privacy Act, which defines all the things that we've talked about. You've got Graham-Leach-Bliley, which is the federal law, which defines everything we've talked about. That goes all the way back to the Act Cyber Guide 1.2, 1 and 2 and 3 coming out shortly. And all that talks about the fact that the data breach language must be adhered to. And even in the old contracts, if all you're looking for is must comply with state and federal laws, that's the minimum. Okay, but if it brings all of this in, so you understand that, and then obviously it goes all the way into the national and mutual contracts that we discussed, which are very rigid in the fact that the agent will pay all the costs incurred by the insurance company if there is a data breach, and pretty much that's going to bankrupt an agency.
Okay. We got a few more. I think we got time maybe for one more question. What can you tell me about third-party providers and data breach?
Okay, third-party providers and data breach. Again, we've talked about this. You must make absolutely sure that the information you send to the third party, that they will cover that under contract. If you do not have a written contract with that third party provider and there is a data breach, you will pay the costs that are incurred within those sets of claims. And again, this is out of your control. It's with a third party, but you are now responsible for it. So very critical that all those things are in place.
Okay, that's all we have time for today. As a reminder, this webinar was recorded and will be posted to the website probably within the next 24 hours or so, for sure by Monday. So once again, thank you for attending and hope to see you at our next webinar. Thanks, everyone.